Hey y'all, mic check, mic check, 1 2 1 2. Let me know if you can hear me. Just making sure before I start. Okay, Sharon, thank you. All right. So I know that the judges, especially because it's already 9:20, she might have already even ruled on this already, but I want to read it. I still gotta catch up. And then that's why I also gotta catch y'all real quick on the Love responded to one of Steele's motions in limine. I already put the thumbnail up for that, so you can just turn on notify me for that one. It'll most likely be right after this live. We'll just finish. I just want to keep my topics separate, keep it clean. But okay, so let's get into it. So this is the state of Georgia versus Jeffrey Williams et al. And this is the state's motion to reconsider oral order striking witnesses' testimony and related exhibits. I put Hilton on the thumbnail, but Hilton is not the one that signed this, but she is the one that was questioning Dennis when it all went down. So she's on the thumbnail. But it says, comes now the state of Georgia and respectfully moves this honorable court to reconsider its October 17th, 2024 oral order striking the October 17th, 2024 testimony of witness retired investigator T. Dennis and related exhibits and precluding his future testimony as a sanction for an inadvertent, non-responsive answer during his testimony. In support thereof, the state shows the following. Background. During Investigator Dennis's testimony, Investigator Dennis referred to actions defendant Diamante Kendrick performed immediately after his release from custody. Defendant Kendrick moved for a mistrial, which this court appropriately denied. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17th, 2024 testimony, precluded him from testifying in the future, and struck from evidence exhibits which Investigator Dennis had authenticated on October 17th, 2024. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17th, 2024 testimony, precluding the witness from testifying in the future and excluding exhibits which had been admitted through that witness on October 17th, 2024, was improper as an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse those portions of the court's oral order. Analysis. Evidence exclusion is an extreme sanction and one not favored in the law. State v. Smith. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly construed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation. Burns v. State. Rule 402 provides in relevant part that all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise provided by law or by other rules as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. That is, Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17th, 2024 testimony of his future testimony or the related exhibits. So they want his exhibits back in. They want him to be able to testify in the future and keep in his non-offending portions of the testimony he had for October 17th, 2024. Where a purported ground for evidentiary exclusion does not come within the exceptions enumerated in Rule 402, it finds no home in any of the specific and detailed exclusionary rules included in the new code and is unsustainable, State v. Orr. As the Supreme Court of Georgia has said, the universe of specific exclusionary rules is limited by statute. First, Georgia's Rule 402 explains that otherwise relevant evidence may be excluded based on rules grounded in constitutional or statutory authority. The evidence code's specific and detailed exclusionary rules are the obvious example. or 305 Georgia, and then they also have the OCGA that they cited. Grandfathers in old common law exclusionary rules, those rules which predate Georgia's current evidence code, in the rare instances, if there are any, when such rules haven't been modified by statute. See Chrysler Group v. Walden. Rejecting the old party wealth evidence rule as abrogated by the new evidence code. That's it. That's the list. Under our evidence code, these are the only possible sources of specific exclusionary rules. Okay. I'm going down from their citations. Okay. Stockard v. Rogers. This is consistent with federal interpretations of the corresponding federal rule of evidence 402, which has a prospective effect in that it precludes trial judges from future creation of new exclusionary rules of general applicability. While OCGA 24-6-611A, Rule 611, permits a court with control over the mode and order of witness examination, Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. Rule 611A mirrors Federal Rule of Evidence 611 as that rule read in 2011, Smith v. State. Thus, Georgia courts look to federal authority for its interpretation. The state submits that federal courts of appeal are very clear. Rule 611A does not authorize the wholesale exclusion of evidence. Unlike the vast majority of the other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. I'm going down. Although decisions that a court makes under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. Where a trial court orders such an exclusion, the Fifth Circuit held that the court erred as a matter of law and therefore abused its discretion in relying on Rule 611A to preclude the government from calling the witnesses necessary to present admissible evidence. Okay, so they're saying they're quoting and abused its discretion. Okay. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions and does not involve a violation of other rules which have a statutory provision for exclusion, such as the reciprocal discovery rules. As there is no constitutional right or statutory provision which authorizes the exclusion of Investigator Dennis's October 17th, 2024 or future testimony generally or the exhibits related to it, the order excluding such evidence was in error and should be reversed. Hey, Ms. Lady One. Conclusion. For these reasons, the state respectfully moves the court to reverse those portions of the court's oral order in which it struck the entirety of Investigator Dennis's October 17th, 2024 testimony, precluded Investigator Dennis from testifying in the future, and excluded exhibits which had been admitted through Investigator Dennis on October 17th, 2024, respectfully submitted the 17th day of October 2024. Ms. Cutie Pie said they should just shut up. The judge could have ruled a mistrial. Yes. I think that I don't know what she's going to decide because a lot of times she allows them to wear her down. So I don't know if she's going to stand strong on this ruling or not. And hopefully she'll be addressing it today now. But hopefully the defense is able to maybe challenge that, present their own case law. Because of course the other side is not going to present case law that would not support their point. So hopefully the defense presents some case law. Hopefully the judge is already aware of some case law that supports her original oral order. I hope she does not let them wear her down and reverses her oral order. And I'm with Miss Cutie Pie. She could have just gone ahead and ruled out of the 46 plus requests of a mistrial. It could have been a mistrial at this point. I hope she doesn't reverse her order, though. I also believe that this was the straw that broke the camel's back. And because she had finally seen for herself, this is a pattern that won't stop. I pulled a quote for, I got to the part where she went off on Brown and she said, what the court wishes is attorneys that know how to try a case or be a part of a trial. So she is tired of them to say that out loud. It is on record, it is on live stream. She's tired. I need her to keep her foot down. As Sharon, yes, keep her foot down on this. Please don't reverse it. Lord, please don't. We will see. All we can do is react, but I need this to stay because also, again, what we talked about was that Gaither deferred a lot, in my opinion, when she was on the stand. She deferred a lot to Dennis did that. Dennis did that. And they know that. That's why they can't go back, because the defense will be like, that's hearsay. And now they try to get Gaither to say things that only Dennis had investigated or done, been directly involved in. So they need Dennis. They need Dennis. They need him. Miss Cutie Pie said they put a different retired officers on the stand that was supposed to testify about other things, but the DA said the same questions they asked Dennis to get evidence back in. I'm not surprised, Miss Cutie Pie. I am not surprised at all. Okay, y'all, catch me on the the next live that's coming up. We're gonna look at Steele has a motion in limine, and Love is has actually, responded back in writing a response to the motion in limine. So we're going straight over there to do that because I'm trying to knock these out so I can get back to my notes and we can do our recap. So, all right. So I will see y'all in like 3 minutes or so. But all right, hey Bonnie, hit the replay. Well, Bonnie, just come to the next live. Hit the replay for the other one later. All right. Oh, he had another interview? Okay, Miss Cutie Pie. Please email it though. I try to stay out of my DMs as much as possible. Trending at some point at gmail.com. Yeah, please. And thank you, Miss Cutie Pie. Replay game. All right. See y'all in like 3 minutes. Bye.